Welcome, everyone. David Korman from Korman's LLP, partner at Korman's, is with us today, again for an amazingly informative session. David, we can't thank you enough for joining our brokerage almost on a bi-weekly or at least once a month basis to get us informed and ahead of the game. Today's session is quite interesting, and I think a lot of people go through this where clients are buying and selling, the closing and the purchase is happening at the same day, and sometimes there can be many problems associated with it. I've been faced with this a few times, and I'll tell my stories at the end of the session. But I am going to let David do the presentation.
Okay, thanks, Sabiha. And yeah, I got to apologize. I talked to Sabiha before we started, but I heard you had a great event last Monday, and unfortunately I was out of town. Unfortunately, I missed it because I would have, it's one of those things you just want to be in two places at the same time. So I was thinking about you. I know we were well represented with Jonathan and Tame were there, and they told me all about it and had a great time. And others have told me too how great it was. So congratulations to everybody, all the award winners, and to Sabiha and David for putting on such an event, with a good event with your committee that supports you so well. And I heard everybody had a good time, and I hope to be at the next one. But I'm glad I'm here today. And today's topic is something that is sort of market proof, because this issue comes up when we're in a good market. This issue comes up when we're in a bad market. There's some nuances that always come up, in a market that's a little more difficult to deal with, like we are today. Just because right now we're in aside from the fact that we're in a slow market, we're actually in a market, from my point of view, that it's harder to get transactions closed, because issues come up often very late in the day, especially dealing with financing, and that's what most of it is driven, where people all of a sudden don't get the financing they thought of. So it's this is a type of topic we've got to think about all the time, and you as an agent got to think about it as well. So I want to run through it. So we'll get going on this, and I'll skip through our usual intro slides. I think you all know how to contact me and reach out, anytime, privately, publicly, however you want to get me. Look for me, look for anybody else in my office. Please tune in David and Dave Real Estate. We've talked about this topic not too long ago in one of our podcasts, and we cover a lot of issues too. So check it out. Check out the podcast, see what's coming next, see what's in the itinerary, and see that there might be some past podcasts that are worthwhile you tune in. So check it out whenever you can. And so let's get into it. So buying and selling on the same day. Okay, so you've got clients that are buying a property, you got clients selling a property. The most convenient thing for most people is, if everything can line up properly, is if you can do it on the same day. You load up the truck to move out in the morning. While that's going on, we're busy at my end. The lawyers are closing the transaction, getting the funding together, exchanging the documents, etc. And then the transaction's closed, and maybe by the time you got the truck loaded up, there's keys available for the buyer to move into their new house and do it all the same day. So obviously there's huge conveniences to do that. And but the key thing you got to keep in mind is, in order for someone to complete their purchase, they need the funds from their sale. So we get asked all the time by agents, should we do that? Our clients are buying and they're selling. Should we arrange it to do it on the same day? Can you close it on the same day? And the easy answer, the short answer is yes. And we do it all the time for the clients. Like there's no greater complications. But I want to go through this because there are certain risks that come up for doing it. And we'll just talk a little bit about how we deal with it when we're dealing with those type of risks. So, we close transactions of purchase and sale for the same clients all the time. There's no problem in doing that, but you have to understand that there are some potential pitfalls that we have to look out for. So the short answer is yes. The more complete answer is yes, but, because there are these risks of same day closings. And I don't want to discourage anybody by listening to this or watching this that they think maybe they shouldn't do same day closing. I want you to just understand and appreciate that there's certain things that have to happen in order to make sure that it does close, and that there are risks associated with it, so that you understand it, you relay that information to your clients, so they sit down with you and map out a plan, a game plan of, should we close on the same day, or, what happens if A, B, and C, and what their personal situation will be if something happens. So there are certain factors that are just unpredictable and variables in the closing date. And sometimes these come up, and they come up late in the game, and it creates a problem. Sometimes it's just, regular transactional problems. Most of the time these days, it's the issues come up because of the financing, and there's certain unsatisfied funding conditions. There were certain conditions that had to be met at the underwriting stage with the lender that haven't been complied with. So there's timing issues like that. Sometimes it's just a question. These days, we're experiencing it way too often, that the lender is allowed, under the terms of their commitment, to do an appraisal a day or two before closing. So they may have already done an appraisal like a month or earlier, when the agreement of purchase sale was signed, and they've approved the financing, but in the fine print of their approval, it says the lender has a right to do another appraisal before closing. And maybe it's a month, maybe it's 3 months later, and they do an appraisal on a market like today. They might say, oh, the value's gone down. We're not prepared to give you as much money as we told you we were going to give you a month ago or 3 months ago. And all of a sudden, the buyer's short on financing. So these are type of issues that come up that could either delay the closing or prevent the closing altogether. And I'm not talking about just your client's financing, for them purchasing, but we start with the sale process. Your client is trying to sell their property, complete their sale, so they have the money to complete their purchase. So what if their buyer all of a sudden runs into a snag? You have no control over it at your end. I have no control, but I'm not acting for that buyer. They got their own lawyer, and that buyer runs into a problem last minute or late in the game, last couple of days, with their financing, and all of a sudden they can't close to complete our sale. We need to close the sale in order to complete the purchase. So you can see how this thing can start to snowball and back up on us. So obviously we can't close our purchase until we get the funds from the sale. And we need that not only on the day of closing, but we need it to receive it in a timely manner on the day of closing, so we can do something with it. So let me run through two different scenarios that we sort of come up with in these situations. So scenario one that I've got here in the slide is that the buyer's financing is delayed. And by buyer, I mean not our client, our mutual client that's buying and selling. It's the client that we're trying to sell to, the buyer that's buying from us, that we have no control of. Their financing is delayed. So that buyer would come to us. Usually it's between lawyers at this point, not between you as agents, because it might be a day or two, or if we're lucky, it might be a week before closing, but sometimes it's a shorter time frame. And they say, hey, we can't get our financing. We're supposed to close on March 9th. We can't get our financing today. The lender told us, that they need a few more days. We need an extension. Okay. So now the buyer's saying we can't close, we need an extension. So that's one scenario. And that's the better of the two scenarios, by the way. The second scenario is the buyer says, we can't get our financing altogether. We thought we had approval. We can't get enough financing to close the transaction. We are not going to be able to close our transaction at all. We do not intend to close because we have no ability to close. We can't get financing. We thought we had it all approved. We thought we were getting 75% of $1 million. Lender just reappraised our property at the one that I'm buying for $1 million. They just reappraised it at $900,000. They're only prepared to give me 75% of $900,000. We can't make up the shortfall. We've tried everywhere. We can't close. So that is why I'm saying that's the worst scenario. An extension for a couple of days is much easier to deal with. Scenario number two creates a lot more headaches for everybody involved. So let's go back to scenario number one for a second. So now we got a buyer who you're not acting for, I'm not acting for. Like, this is the third party buyer requesting an extension on the property we're trying to sell. So now we have to, at our end, usually request an extension as well, to match the dates, because we can't buy until we get the proceeds of this sale. So now we're asking another party, the party that we're trying to buy from, if they'll agree to an extension for a couple days or a week or whatever it is to match up again, because we're trying again to match the closing date for our purchase and our sale to happen on the same date. Now, that seller might say no. You might just deny it. And if they just say no, we're not doing it, we're supposed to close with you March 9th. That's what our agreement says. You're not ready to close. You're in default. Your buyer's in default. We're keeping their deposit. We're going to sell to somebody else. We're going to reserve our rights to sue your client, because they don't have to agree to an extension. Or they might say, yeah, okay, we'll agree to an extension, because that's, we're going to try and convince them to do that and negotiate to agree to an extension. But that's always going to be on certain terms that are going to be imposed. And for sure, one of the terms would be that the buyer who's now requesting this extension is going to cover the seller's costs for this extension. They may want an additional deposit money. They may want some funds released to them from the previous deposit money. They want their legal fees covered. There'll be a whole shopping list of extension requests. So, but that's a better scenario, because usually we can try and negotiate something and try and get people to act reasonably, and hopefully we're able to negotiate an extension, because now we're trying to negotiate an extension again to match our closing dates. So we can still buy and sell on the same date, but instead of it being March 9th, maybe we're going to be, at March 16th and still try and do it on the same day, because again, we need the sale proceeds in order to complete the purchase. But now we're incurring costs because we need an extension, and those costs aren't our doing. We only had to request it because we have a buyer that had a problem and need an extension from us. So if we're going to agree to that, obviously we're going to want those costs recovered, because we want our client to be covered, and we'd like to get them to cover the costs that we're incurring on our other end, because we got another innocent seller that's agreeing to an extension there. And so now we're negotiating on all different levels, and you can see there's a whole chain involved. And we have to resolve all that and get everybody to agree and be on side. Who's paying for what costs, and how much are those costs going to be, and what those terms are, and negotiate that all out in order for us to get an extension for that 1 week to close both transactions same day again on March 16th instead of March 9th. And I could tell you from my point of view, we'll spend more time and effort trying to negotiate these extensions and the terms of these extensions than we would just closing the transaction in the normal course. So obviously there's going to be additional legal fees involved at my end. Usually the innocent parties are asking for the parties that need the extension to cover some of those legal fees, sometimes all of those legal fees as well, because it's one of the costs that are incurred. So that's where we're going to be if we're in scenario number one. Okay, scenario number one again is the buyer, the person that we're trying to close it needs an extension. That causes a chain reaction, but at least we got parties trying to negotiate, and hopefully we're going to negotiate terms and extension and close on a new closing date. Scenario number two, again, is buyer saying, I can't close on March. I can't close at all. I can't get the funding. So I'm going to default to you. Sorry, but I'm defaulting to you. I'm not closing on March 9th. Well, and our position is going to be, okay, we're going to keep your deposit monies. We're going to sue you for costs. We're going to reserve our rights for damages, blah, blah, blah. But our bigger practical problem is we're supposed to be closing our purchase today. We don't have money to close our purchase. So if we're really lucky and our mutual client has deep pockets and alternate means of cash to come up with, maybe they can still close their purchase transaction without getting sale proceeds from their sale. Most people don't have that. Okay, the majority of our mutual clients aren't in that position, and they need the proceeds from the sale in order to complete their purchase. So that creates a difficult position. So you always want to look at, okay, what are the legal implications, but also what are the practicalities of, when this happens? Because now we're in a default situation. So yeah, it's easy to say, we're reserving rights and we're going to sue you, blah, blah, blah. In the meantime, we're planning, we got a moving truck pulling up. We're supposed to be loading up our stuff and moving into a new house that we can't close on. Okay, so it creates a serious problem. And one of the reasons that we've got this legal problem, and I want to just point this out, I'm always pointing out this clause in your agreement of purchase and sale. Every standard printed form agreement of purchase and sale has a clause in it that basically says time is of the essence of every part of the standard agreement of purchase and sale. Now it's a different clause, and depending which form, it's paragraph 20, I think, on the AREA standard agreement of purchase and sale, and I think it's 23, paragraph 23 if it's a condominium form, but it's the same wording. It's the exact same clause, and it basically says that time is of the essence of every part of this transaction. So, and that the time can only be extended by a written agreement between the buyer and the seller, or by their solicitors on their behalf, who are authorized to agree to any change on their behalf. So time is of the essence. So that means there's a couple elements in an agreement purchase sale where the time factor is really important. So the first one is the irrevocable date. You put a date in there and a time in there, and you've got to adhere to it. You've got to sign it back. It's open for acceptance just until, if it says 5 p.m. on March 9th, then it's 5 p.m. on March 9th. It's not 5:01 p.m. on March 9th. So that's the first one. The second one is the time where we can search title and provide our requisitions. We have a title search day. We can search until March 9th. That means if we don't search by March 9th and send a letter to the other lawyer by March 9th, then the lawyer doesn't have to clean up any title problems we might find. The buyer has to accept the title with all its warts and flaws. So we have to meet that time frame. But the one that's material for today's discussion is the closing date. When it says that the transaction will be completed on March the 9th, it has to be completed on March the 9th. Nobody is entitled to an extension. There's no unilateral right to an extension. Time is of the essence, which means it has to close on March 9th. And if one party or the other doesn't close on March 9th, they are in breach of the agreement of purchase and sale, and there's legal consequences that will flow from that. Okay, so the important point that you have to know, your clients have to know, is that there is no unilateral right to an extension. So if a defaulting buyer comes to us, oh, I'm really sorry, I can't close, I need a week or I need 2 weeks, they're not entitled to that. Okay, at law, our legal position can be no, closing March 9th. If you don't close today, we keep your deposit money, we're going to sue you, blah, blah, blah. Okay, now, always important to understand the legal rights, but then we look to the practical solution. Does it make sense? Does it make more sense to not terminate the transaction, put them in default, and to grant an extension if we can work out reasonable terms of an extension? Because usually everybody's better served if we can do that. But that is a negotiation. It's not a right. And there's no extension that's agreed to unless it's in writing, agreed to by both the buyer and the seller, or by their lawyers on their behalf, if they're so authorized to agree on their behalf. So we get into that extension right. Okay. So that's a really important concept to always keep in mind. And that's why the law is what it is, because time is of the essence. It's not a suggestion that the irrevocable is at a certain time. It's not a suggestion that you search title by a certain date, and it's not an extension, a suggestion that we close on March 9th. It's a requirement that it has to close, and failing to do any of that, there's legal implications for it. So that's what
I said. I won't ask anything in the middle and wait till the end, but I can't hold myself because it's
okay.
so I put this down because we had a landlord tenancy board representative, a paralegal, that gave a webinar yesterday. So I thought I'd ask you this question during your session today, and I think this is a really good point to time to do it. So now with the new regulations and with COVID and all of that, tenants are behaving in a certain way. even after, like we discussed this, that even after N12 is signed, which is mutually agreed upon acceptance that the tenant is going to leave the property at, some time. Closing date time comes in, tenant doesn't leave the property, right? And so, and the buyer's asking for vacant possession. It's also typed in, in the clause, but it's also in there. What what happens to, like, if the who is to be held responsible for that expense that is incurred? Is it the seller solely, or can the seller go after the tenant in a
Yeah.
sense like that?
Okay. Well, there's two different things there. There's a contract between the buyer and the seller, and then there's a contract between the seller as landlord and their tenant. Okay,
Mm-hmm.
that's the lease. Those are two contracts. So let's deal with the first part. The standard agreement of purchase and sale says we're closing on March 9th, and in the printed form it says upon closing, vacant possession will be given to the buyer unless otherwise provided for somewhere in the agreement of purchase and sale. So again, that's not a suggestion. Okay, it's not like, oh, I prefer vacant possession, but if I have to take a tenant, then if the tenant's there, the tenant's there. It's not like, that's not the way it works unless that is specifically agreed to in a schedule to the agreement of purchase and sale. Because you could negotiate that the seller will try and get the tenant out by closing, but if the tenant's not out, the buyer agrees to close anyways and assume the
Yeah,
tenant.
that's the clause that I'm asking. Like, that can you be held? Like, can we do that? Can that clause be added and actually used at the time of closing, or is it something that is not going to be considered because of the fact that you are supposed to close?
Yeah, look, you can try to get something like that in if you have a tenant, but most buyers won't accept something like that. But it depends on the buyer's situation. If the buyer doesn't have to move right in, or is okay with there being a gap between the closing and the time that they have to be out of wherever they're out of, they might say, fine, like, I really want this house, so if you can get the tenant out by closing, great. If it's going to be 30 days after the close, or I have to assume the tenancy, then I'll get them out. I'll bring the application to get them out, that I need this product for my own purposes. And sometimes a buyer's prepared to do that. And then you put that type of clause into it. Okay. But in the absence of anything like that, the agreement says vacant possession. The seller has to give vacant possession. If the tenant said, I'm going to move out, and the seller goes ahead and signs an agreement because the tenant agreed to move out before closing, and then the tenant doesn't, we got a big problem on closing, because the buyer's not going to want to complete the closing because the tenant's not out of there. So either we're back to a negotiation. The buyer could take the position, I'm not closing at all. You can't deliver what you agreed to deliver on closing, which is vacant possession. Therefore, the agreement's at an end. Give me back my deposit money, and the agreement's over, and I'll go buy something else. That's one solution, and the buyer's within the right to do that. The other would be, okay, seller, when can you get the tenant out? Like, what's going on? What's the negotiation? Did the tenant say he needs another week, a couple days? Because maybe we work out terms of an extension, but I don't want to close until you get the tenant out. So maybe I'll give you a week, or I'll give you 30 days to get the tenant out. And if you do that, you're just resetting if that's agreed to, you're resetting the closing date. Time is of the essence again. And so if you gave him 30 days and we get to that date and the tenant's still not out, the buyer's still in the same position. Okay, I don't want to extend anymore. I'm going to terminate. Give me my money back. Okay, but the onus goes on the seller. The third scenario is a buyer is saying, okay, you couldn't get the tenant out. I'm prepared to close anyways, and I will take on the responsibility of getting rid of this tenant, because I can bring an application to get the tenant out because I need the property for my own purposes. I don't need to get in there the next day. I've got a place to live in the meantime. So if it takes me 30, 60 days to go through the tribunal to get an order to get the tenant out, that's fine. But I want to close and take ownership, and I'll do it. But those are all things that have to be negotiated at the time. Okay. Bottom line is if it says vacant possession, that's what the buyer's entitled to have on closing. Otherwise, the seller's in breach. Okay, does that answer it? Okay. Sabiha, you're on mute. Is that okay?
That's perfect. Thank you.
Okay, great. Okay, so that's the first part I wanted to point out with time is of the essence. Okay, no unilateral right to extend. The other thing, time factor, that's really important on this is, let's say they do close on time. We get the purchase completed on the closing date. Okay, so we've done the first part of our transaction. We've now completed the first part. We've got the proceeds, and now we want to close the second part. So we've completed our sale, our mutual client's sale. We got the proceeds. So now we want to complete the purchase. So we closed on time, the right day. We closed March 9th, but we have a timing factor even on the day of closing, because when we're selling, we would always ideally like to be able to close that sale early in the day to get the proceeds on as early as possible so we can use the money to complete our purchase. But sometimes we don't get it early in the day. We get it really late in the afternoon. Okay, so we successfully closed. So the sale proceeds are available to us. So we have money to complete our purchase, but we don't have it early enough in the day to be able to transfer those funds out to the seller's lawyer in order to complete our purchase that day. So that creates a timing factor too, and we have no control over it. Like when we say time is of the essence, so we're selling our property. The buyer, it doesn't say that it has to close at 12 o'clock in the afternoon or 1 o'clock or 2 o'clock. It has to close that day, and it has to close when the registry office is open, which is open till 5. So we can only register until 5 o'clock, but we're still allowed to close a transaction up until 6 o'clock. So if we get money in our trust account at 5 o'clock or 5:02, and we know it's in our trust account, but we're out of time to register, we can close in escrow, especially when there's title insurance involved, because they protect the title. So the parties agree that we're closed, but we'll hold on to the money till the next morning. We'll register first thing the next morning, but the keys can be released to the buyer. As long as we have the funds before 6 o'clock, we can make those arrangements. So even though the registry office is closed, we can't legally transfer the title, but there's an arrangement made that's accepted practice, especially when there's title insurance, that we close in escrow to allow the buyer to get their keys and get in, because the because the seller's lawyer's got confirmation he's got the sale proceeds in his file, in his trust account. So, and there's title insurance coverage that will cover in case somebody, we go to register the next morning, and let's say somebody registers a lien or something on title before we get a chance to transfer the ownership. Title insurance coverage will protect the parties from that, and they call it gap coverage, and they allow us to close. Okay, so there is that way of doing it, but we would have to be able to get that money in and then transfer it to the to the seller's lawyer in time to even do an escrow closing. So we can't always do that. So like the scenario that I'm talking about here is the sale closes at 4:59 p.m. So we've got the money, but we're out of time to deliver certified funds to the seller that day. Okay, because we got to give them certified funds, whether it's, we now received the money, we're issuing a bank draft or certified check, and now we got to run over to the seller's lawyer, or even if we're doing the transfer, which we're doing more often than not, by wire transfer. The wire transfer takes some time too. We still get confirmation that the money's in, it's cleared, it's certified, and then the money has to be transferred. So sometimes we run out of time to complete the purchase. So even though we got the money in, it came in too late in the day, on the day of closing, but too late in the day for us to be able to use that money to complete the transaction with our seller. So now we got to go to the seller and say, hey, we need an extension. So now we're in a bit of a predicament, because the property that our mutual client had been living in and just sold is now successfully transferred to someone else. Somebody else is moving into that property. Our client's stuff is all in a moving van, and they got nowhere to go. because we can't get them the keys until the following morning, because we can't get the funds to the buyer's lawyer's trust account in time to do an escrow closing. So they can't sleep in their old house. That's gone. They don't own it anymore. They can't sleep in their new house because we haven't closed and we haven't been able to do an escrow closing, and their stuff's in a moving van and they got nowhere to sleep and they got to store their stuff somewhere. So that's a scenario that we run into. So obviously it's better for our mutual clients if we consider other options to avoid putting them in any of these situations. So let's consider what some of the options would be. So the easiest option is to not close on the same day and leave a gap in time between the closing dates for the sale and the purchase. So there's two different scenarios for doing that. And I'm sure you should be always working these type of scenarios out with your clients based on their own fact situation and their own financing and their own situation, what their options might be. So if we're selling first, okay, your clients are going to buy and they're going to sell. So you're trying to figure out what's the best way to do it for them. So if they sell first, that's a great way to do it. If you arrange for your sale on March the 9th, Thursday, March the 9th, and maybe you make your purchase on Monday, March the 13th. Okay, so they got a few days. So, but meantime, we closed on their sale today, so they're out. So their stuff has to be stored somewhere, either with friends or family, or it stays with the moving company. It's got to be stored for those few days. So they're going to incur those storage costs, and they have to have a place to live Thursday night, Friday night, Saturday night, Sunday night. So for some people, that's a great scenario. They might have an ability to store things in facilities that they own. People store it sometimes in their own business might have a warehouse, or they might be easy for some people if they got a friend with a warehouse, or they get some arrangement, or they do it with the mover, and it costs them a certain amount of money to store it, but it might still be a good scenario. They might have a place to live for a couple nights. They might just be able to go in with family or friends for a few nights. Maybe you, as the agent who's a full service agent, offers them to sleep at your house. I know some of you, probably have put in bunk beds just for that type of purpose, to help your clients out, because you don't want them sleeping on the street. It doesn't work for everybody, but for some people, it's a really good scenario to do it this way. And when you factor in the cost of storing stuff, or even getting a short-term rental, maybe they're just getting a hotel for a few days, or an Airbnb for a couple of days, that sometimes could be a really good scenario for them to make sure that they sell first. They've got the proceeds before they need it for their purchase. So let's look at the other way. What if they buy first and then they sell? So how do you do that? You need the money from your sale proceeds in order to buy. So the way you do that is by arranging for a bridge loan. Okay, and some of you might be very familiar with it. For those of you that aren't, this is the most important takeaway from today's discussion. You should always be encouraging your clients to consider getting a bridge loan, whether you're closing on the same day or even if you're closing a few days apart. Okay, I would argue either way, they should consider arranging for a bridge loan just in case. Okay, so if they do have a bridge loan, they can close on at the same time. Okay, they can own, not the same time, they can own, in essence, two properties. They own the property that they own. They haven't sold yet. They haven't completed their sale yet, but they can still buy the new property. Okay, so March 9th, today is the closing for buy. If they have a bridge loan available to them with sufficient funds to complete the purchase, they buy their second property today. Their sale of their existing property isn't happening until next Monday. So for a period of 4 days, they're going to own two properties. Okay, so if they do that scenario, this in a lot of ways is so much less stressful for them. Okay, they can close today. They've got from between today, they got tomorrow, today, tomorrow, all weekend to take their time moving in, to get settled, new place, to clean it up, to do some painting, to do whatever they want to do. They got a few days. It's easier than getting your stuff on a same day closing, packing up the moving van, having the van sit for a couple hours, waiting to get keys. And then you get the keys at 6 o'clock at night, and now they got to unload, and you got to try and get the beds all set up and get the kids to sleep. And it's hard to do it all in one day. That's one of the disadvantages of a same day closing. It's hard. It's easier if you have a gap of a few days. Okay. You close today, you got a few days, paint, renovate, do what you want to do. It might be a few days, might be a week, might be 2 weeks. Okay. But they don't have to leave where they're living until their new place is in good shape for them to move in. So it's a lot less stressful on them. So it's a better way for your clients to go, and you're adding value by making those type of suggestions and arrangements. But they can only do that if they get a bridge loan, because they have to have enough money to own 2 properties at the same time. So let me break down a little bit of what a bridge loan actually is. It's a very short-term loan that's intended to just bridge this gap. That's why it's a bridge loan. It's bridging the gap in time between the time that the existing home is sold and the new home is purchased. You're buying first, you need a few days, or you may need a week, and you need this loan for that period of time. Okay, so it enables the use of the equity in the home that you're selling to complete the payment on the home being purchased, because the lender is going to say, okay, what the lender really wants in order to give you a bridge loan is they want to see you've got a firm sale. Okay, they want to see a copy or agreement of purchase and sale that shows that your closing date is on March 13th and there's no outstanding conditions and it's all been waived. So usually they're prepared to say, fine, we will give you this loan for 4 days so you can complete your purchase first, because you're going to sign the bridge loan documents, which is really consists of you promising to pay us back the bridge loan on Monday, March the 13th. And we want confirmation from your lawyer. We want Korman's LLP to sign an undertaking and confirmation that they're acting on the sale, closing on March 13th. It's scheduled to close March 13th. There's no issues. And they agree that they will repay the bridge loan from the closing proceeds on March 13th when the sale closes. So that's usually all the lender really wants for a bridge loan. Okay, those 2 things. They want a promissory note from the buyer saying, I promise to pay you back this bridge loan as soon as my sale closes, and I will instruct my solicitor to pay you from the sale proceeds. So that way the lender is saying, okay, I'm putting this money out for 4 days and I'm going to get it back. Okay, or it might be a week, or it might be 2 weeks, whatever is agreed to, but there's a time when the lender knows they're going to get it back. And part of the documents that the lawyer signs is, and the undertaking from the solicitor to the lender is also, if there's a change in the closing date, we will let the lender know. So now we're supposed to close on March 13th, but what if that buyer runs into one of these problems that we talked about and says, oh, I can't close March, my funding's not available, I need till March 15th. So now, and they're asking for an extension. So if that happens, we have an obligation to tell the lender that gave the bridge loan, hey, newsflash, we can't close on Monday. We're negotiating an extension, or we've agreed an extension for 2 days. We're now closing. Here's a copy of the extension agreement. We're now closing on March 15th. So we will pay you back on March 15th for the bridge loan. And why I tell everybody they should arrange for a bridge loan with their clients is the lenders generally don't charge anything for approving a bridge loan. The client's only going to pay for an administration fee to the lender if they actually use the bridge loan. So they can arrange it, I'll be available to it. But if they never use it, they don't need it to close a transaction, they don't get charged. And even if they do get charged an admin fee, it's a few $100s. Like it's really peanuts in the grand scheme of everything to have that bridge loan available just in case you need it. Okay. The other great thing about a bridge loan right now is that interest rates are so low. And I know you're saying, what do you mean interest rates are so low? They just doubled in the last couple months from what they were. Well, interest rates at 2%, I got a news flash for you. It's never coming back. Maybe not in our lifetime. That wasn't the norm. That's not where interest rates historically are. Where the interest rates are right now is much more of a norm. 4, 5, 6%, up to 8%. Usually interest rates are going to be somewhere between 4 and 8% and fluctuating ups and downs there. It's not likely to get back down. But even at 4% or 5% or 6% for a bridge loan for 4 days, when you do the math, it's peanuts. Okay, it's really inexpensive. Obviously, it was even less expensive when they could borrow a bridge loan at 2%. But for 4 or 5 days, or for a 1-week bridge loan or a 2-week bridge loan, it's not a lot of money. It's really an inexpensive loan, both from an administration fee point of view and from the interest. Okay, now the lawyers acting for doing a bridge loan, we charge a fee as well. We'll charge a fee to put the bridge loan and provide, and deal with it with the lender, because it's still a loan. We still have documents, whether it's a promissory note, or undertaking from the solicitor. We still have that. We got to get the bridge loan advanced. When we close on the sale and pay the bridge loan back, we have to go through a process of getting a discharge statement, and we're discharging the bridge loan just like we're discharging a mortgage on title. So there's some legal fees involved too, but it's small amounts. Like, it's really minuscule in the big scheme of everything. So it should never be a reason not to do it. And it's a reason why I highly encourage it. And like I said, most of the time for a bridge loan, the lender only requires 2 things, especially if it's a short-term bridge loan of a few days or a week or 2 weeks: a promissory note and an undertaking from the solicitor acting for the seller to pay it back with interest from the sale proceeds. Okay, so it's an unsecured loan most of the time. Now, most of the time, which means not all the time. Sometimes usually it might depend on just the credit worthiness of the party and how extended they might be with loans, etc. But it's usually triggered more by the gap in time. So if it's a larger period of time between the closing dates of the purchase and sale, like if it's beyond 2 weeks, or maybe it's a month, or if it's anything more significant, like 2 months or something like that, a lot of times the lender will still agree to a bridge loan, but they're saying, we're not happy with a bridge loan just secured by a promissory note and an undertaking from the solicitor to repay it. We want some security. So then they might ask us to actually draft up a mortgage, and we'll put a mortgage as security for the bridge loan, sometimes on one of the properties. Sometimes they ask us to put it on both the properties. Okay. Oops, sorry. So sometimes they might say, we want to put a mortgage on the new property that's closing, and which will be a second mortgage, because they might already have, it's usually the same lender. They might be putting a first mortgage on there. Or it might be, we want to put a mortgage on the property that's being sold, or we want to put a mortgage on both properties as security for the bridge loan. Now, sometimes the instructions that we receive from the lender is draft the mortgages, get the clients to sign the mortgages so you have them in your file. But if the sale transaction closes by March 31st, just to pull a date out, you don't have to register it. Just have it in your file. But if the sale doesn't close by March 31st, then we want you to go ahead and register the mortgages on title, because we're getting a little more concerned that the property may not get sold successfully. So we want to make sure we have security. So we run into that sometimes. So obviously, if we have to register the mortgage on title to one or both properties, and then eventually take the mortgages off one or both properties, there's some additional costs involved in doing that, both with the government side in registration costs, and for putting the mortgages on and discharging the mortgages, and there's additional legal fees for dealing with those documents. But again, these costs are minor in the grand scheme of things. And the potential of these costs is just, it's like insurance for your client to have a better process of closing these transactions in a timely basis. And again, the point I'm going to reiterate, interest rates are still relatively low. You know, if we were talking about, okay, I get a bridge loan, but it's going to cost me a 20% interest rate, you know, for a month or something like that, that's different. We're not talking about going to private lenders, and the banks aren't charging that. The banks are charging conventional rates on these bridge loans. They're not that exorbitant. And when you do the math, and it's only for a few days or for a week or a couple of weeks, it's not that expensive. And the administration fees are not that expensive. The legal fees are not that expensive. But this allows some insurance for your clients to deal with all of those scenarios that come up when you know that they might come up. You hope they don't, but they could come up if there's a same day closing. And now you've got your buyer who you have no control over, can't close. You don't have the proceeds to complete your client's purchase, but now we do have the proceeds to complete our client's purchase. We can default that buyer. We can give that buyer an extension, but we can still close our purchase today because we have a bridge loan. So we're going to close on our bridge loan with our bridge loan funds. Okay. And then we're going to deal with that selling our property afterwards. Now, if the buyer was scenario one that I went through earlier that says, I can't close yet, I need an extension, the bridge loan still works, okay? Because we're going to extend and we're going to let the bridge loan lender know about the extension, because eventually they're going to get paid out when we complete the transaction. If we were in scenario two, where the buyer is saying, I can never close, okay? Now our lender, even on the bridge loan, has more concern, and they may want the mortgages registered as security for the bridge loan for them to put the money out. Okay, and we have an obligation as the lawyers acting on the sale, because of the undertaking that we've given to the lender, to keep them informed as to what's going on with the sale of the client's property. Okay, but this is why I would argue to you that even if you have arranged for a gap in the closing, you're not closing on the same day. It's a great idea to encourage your client to arrange for a bridge loan just in case. Okay, so if they were going to close their sale first, and then their purchase a few days later, you never know that when you go to close that sale, if you have a defaulting buyer or a buyer that needs time. And if that buyer does one of those scenarios, if you have a bridge loan arranged, your client still might have an ability to close on their purchase transaction, and it allows them some time to deal with their sale, down the road, by negotiating an extension or even by reselling the property and getting somebody else to buy it. Okay, but at least they get to move into their house on time. Now, if everybody comes through as they're supposed to under their contract and no one needs it, and your buyer client arranged for that bridge loan and they never use it because they don't need to, their sale closed, they got the proceeds, they close the purchase same day, everybody's happy, they never use the bridge loan, they don't pay the administration fee, they're not paying anything, or they're not paying interest on it. They probably still have legal fees to my firm, because we did the loan documents, we arranged for the bridge loan documents, and we got it signed and everything, so we're ready just in case. Okay, but that's a few $100s of insurance just to make sure that they don't run into a scenario where they find out, oh, buyer can't close, we're screwed, we got no ability to close on our purchase, so everybody's looking for litigation lawyers. Okay, and nobody wants that scenario. No, that's not good for anybody. So I strongly recommend everybody always consider a bridge loan, see if that's appropriate for your client, whether they qualify it, what the terms and conditions would be, what the costs would be. And there's all these arguments that can be raised as to why it's a good idea to arrange it, even though you might never use it. Okay, but bottom line is there's lots of ways for us to get transactions closed same day, and we still do it all the time. But we are running into these scenarios more and more, especially with the conditions right now, mainly because of that issue of lenders saying, I'm not giving you as much money as I initially approved you for, or other underwriting conditions that people are running into, because maybe they got their loan was conditional upon both the husband and wife both having their jobs, and someone loses their job or something. Things do come up in a market like this. So you always want to have some insurance, some other ability to get transactions closed. So that's why, the bridge loan is a great tool for that. So with that, I'm going to turn it back over to you, Sabiha. Thanks for attending. I'm sure there might be some questions, so some we can answer now, and others you can reach out to me at any time. But Sabiha, you probably have something in the pipe, I'm guessing.
Yeah, no, you kind of touched on everything because I did have like my whole worry was especially with this with these. David, you're upstairs, but it doesn't look like upstairs. What happened?
What happened?
Do you like the new
David's
interview as well?
background. I was like, what happened to his office? I like his background. I was gonna go
Where are
quick.
you?
It's just a virtual background.
Oh, okay.
Yeah.
Yeah, so my biggest concern was this, right? That this is happening, like it happened to me 2 years ago in March, where the tenant would not leave the property, and it was thankfully just for a few days. But on the basis of that, the purchaser walked away from the deal. And but it happened to be because it was COVID, my client was actually able to sell the property for a lot higher that they had sold the original because it was a rented property. So we were able to paint it, whatnot, and so it worked out. But and especially after our session yesterday, like the question came up is that even with an N12, the tenant can right at that moment say, well, I'm not leaving. And a lot of times we give 60 days notice to tenants, with the buyer moving in with the agreement of purchase and sale as proof that, the buyer is moving in themselves or moving a family member that's dependent on them. And then if the tenant does not leave on 60 days, there's a huge problem. But what you said about the bridge loan is an amazing idea. Having said that, it also has its issues that if the buyer doesn't close at all, then what, right? So
Yeah.
I think you touched on all of these points, which were amazing, David. Um, I had a question that somebody actually asked me, and it's a little bit off topic, but one of our realtors asked me about your firm the other day, and I want to just I didn't have the right answer for it, and they asked that if they're representing the buyer and the seller, and they take the deal to your firm, and you're representing both the buyer and the seller in the transaction, how comfortable are you as a law firm to do that?
Yeah, sometimes we're very comfortable to do it, and we're allowed to do it we got to be careful law society guidelines and how we do that. And we can do it in certain circumstances, but even when we do that, for on both sides of it, we have different lawyers within the office handling the transactions. So, but we can only do it if the clients on both sides are aware of that and they both agree to it. Because part of what they'd be agreeing to is everything is fine as long as everything is fine. And there's no real issue that we can't resolve. But if we do get into a situation where, where there's a conflict that we can't resolve easily, then at that point, we have to send somebody out, one or the other out to get counsel elsewhere. So there are certain scenarios where we will act on both sides, but we're very careful in how we do it and what the transaction is, because sometimes it just doesn't make sense to do it. As much as we'd like to keep it and do both sides of it, sometimes it doesn't make sense. You have the same issue at your end if you're doing, if you're on the, double ending a deal. I got an agent right now in the middle of a real pickle on double ending a deal because there's serious problems with closing this transaction. And she's trying to, be the mediator in between. But really, we told her, like, you got to stay out of it completely right now. And we just have to deal with the other law firm. And we're taking a very hard position. We're acting for one and another law is acting for the other. And we may not agree to anything at the end of the day. And one party or the other might default. And there might be litigation coming out of this. And as much as the agent, thought it was a great idea to double end the deal initially, she's probably going to regret it at the end of the day, because everything that she said is in the process is going to be material and stuff. So we've got to be careful in those situations, and we do as lawyers too. So there's a lot of situations we say, no, this isn't something we're comfortable with. We do it more often when there's a real relationship between the parties, like they're related or they're close friends and they have a certain comfort level. It might be sometimes it's even a private transaction. There aren't agents involved on it. we'd be more comfortable. But even we do that, we have different lawyers acting. But if it's third parties that have nothing to do with each other, they're usually better off if they have independent lawyers, because you never know what's going to come up. So it can be smooth, no issues. Day of closing, all of a sudden someone runs into a problem. Now we got to take an adversarial position. Okay, so even though we have different lawyers within our firm, it opens up a question for the non-defaulting party saying, hey, you know, are you really acting for me, or someone in the other lawyer I was acquiescing to certain terms because you're strong arming them internally. You know, you don't want to raise those issues. So a lot of times we just say, no, it's better if you have another lawyer act on it.
David, I hope that agent files an errors in the mission claim, because it sounds like she's going to need to do that right away, or they, without
look,
knowing
I'm sure
anything
you've also seen a lot of scenarios where, you know, agents have double-ended a deal and everything goes smoothly, and you know, congratulations to them. But
Yeah, and you know, David, a lot of times it's all, sorry?
I'm just saying there's always that risk. And unfortunately, in today's market, that risk comes up a little more often. You know, it's still a small percentage, but it's more often because people think they've got their financing arranged. It's done. They've been approved. They think everything's good. And last minute, something happens. They don't get enough money, or some circumstances change. They don't meet an underwriting condition. All of a sudden they can't close. And now the very friendly transaction, everybody's hugging and kissing, all of a sudden they're at war.
Turns sour. Yeah, that's exactly what I was coming to, that the two issues that I think we're facing in the present market is the financing aspect, that the lenders are, you know, they've approved and all of that, and at the 11th hour, people are short 150, sometimes $300,000 in closing, or the tenant issue arises, which has also been very prevalent since
Tenants just
COVID.
refusing
So
to
those
move out.
two, yeah. So especially, you know, everybody dealing with tenanted properties, or you know, people buying properties which are a little bit over their budget, you know, should be very, very careful. If
Yep.
you're downsizing, no problem, I think, but if you're upsizing tremendously, then it can be a cause of issues. Does anybody have any questions, guys? You can unmute yourself and ask away. We are close to an hour or so.
Yeah, this is Ravi here. How long does this bridge financing arrangement takes, and is it the same lender who has granted the normal financing? And also, what is the cost of bridge financing? You know, if I have to arrange the client.
Okay, like the lenders generally deal with it in a pretty timely fashion, because it's usually the same lender that's giving them the first mortgage, right? You're going to, usually it's the same lender. It's, you know, it's RBC, it's Bank of Montreal, it's Scotia, whoever their institutional lender is. So they've already gone through an underwriting situation with them, because they've already approved the first mortgage. They've already got all the information. So the piece of the puzzle that they need in order to grant the bridge loan is to see the agreement of purchase and sale. Okay, to see that there's a firm, you know, and that, or if there's any, if it was a conditional, they want to see that the waiver of the conditions. So that they want to know, you know, when it's closing, they want to see the price, they want to do the math, they see there's enough from the sale proceeds to pay them off. And, you know, so that's generally what they're looking for. So it usually doesn't take them very long to approve a bridge loan, because they've already done all their underwriting. They've already got all the information from the borrower. Okay, so, but I would tell you, you know, they should be looking to arrange it at the same time they're looking to arrange their first mortgage. So you should apply, I want a first mortgage and I want a bridge loan just in case. And they can get approval for a bridge loan, which will be initially, you know, and we're talking about when they get pre-approval for the mortgage. Yeah, we're going to pre-approve you to get a mortgage up to $1 million to buy a property, but we could also pre-approve you for a bridge loan. But one condition of the bridge loan, it will be subject to you signing an agreement for a sale and then providing us the copy, and we got to be satisfied with that too. So you can get that arranged right up front, you know, on conditional terms, because you can even not have a sale yet, but they say if you get a sale under contract that's closing within so many days or weeks of the purchase closing, we'll agree to give you a bridge loan, but that'll be subject to us reviewing your agreement of purchase sale, make sure it's bona fide and making sure they're happy with the timing, the price that they're selling for supports them getting paid out, etc. So they're always going to want to see that. So that won't firm up until there is an actual agreement of purchase and sale that you can present to the lender. Okay. So that process can start early. Okay. So I would encourage you to do it. The second part is, what's the cost going to be? Most of the institutional lenders are charging like $300, $400, $500, like for a bridge loan, like as an admin fee. It's not really high. So that's all they're paying, that admin fee plus whatever the interest is going to be on that money. And if it's 6% for 4 days on $100,000, like it's not a lot of money.
Okay.
Or it might not be 100,000, it might be $1 million because, to close a transaction.
I was wondering, David, what do we buy here?
I don't know. That's what the chat line said. What was for a $100,000 bridge loan? But if let's say it's $1 million bridge loan at 6%. So I don't know if anybody has a calculator, just do simple interest. 6% for a year on $1 million would be $60,000.
$6,000 for a year, yeah.
So divide that by 365.
Yeah.
And multiply that by 4 days or 7 days. I mean, it's not a lot of money in the grand scheme of it to have that available. That's less expensive than the Airbnb they might move into, or the moving truck that they've got to keep for 4 days with their stuff sitting on it, or putting their stuff in storage. Like they'll incur other costs really fast. That'll be more expensive than a bridge loan.
That can come from the seller as well, right? The seller of the property can sue them for damages too. So all of that can become.
It's also a cost if they do have a buyer that all of a sudden can't close with them and needs that extension for a few days, and they have a bridge loan available. That's one of the costs they could pass by. Say, okay, we're going to give you an extension for 4 days, but we still have to close my purchase today. So I'm going to incur the bridge loan cost. I can use my bridge loan so I can close, but you cover me for the interest of for the cost of the bridge loan for those 4 days or for that week or whatever it is. So it's a cost they might be able to pass on to the defaulting buyer or the buyer that needs the extension.
Okay.
Anything else anybody wants to add? David, are you okay? All right, thank you, everyone. A wonderful session yet again, David, and hope to see you all soon.
Thank you, David Korman.
My pleasure. And anybody has any topics they want, please reach out. Let me know. We can always put something together. I think we've got something else scheduled in the near future. If not, we're going to get something, but we'll be back.
All right.
Thanks.
Everybody.
Thanks.
Thank you.
So Karen has thrown in title insurance, so just for us to make a point of that.
Karen, we have a wonderful episode on the David and David on Real Estate podcast about title insurance that actually Sabiha was a part of as well. So I can email that link directly to the episode over to you, and take a listen to it because there's a lot of great information on there as well.
Yeah, it was a real eye opener for me too on certain topics. So yeah, it's a good session. But certainly maybe David and I can work on something for that as well.
Yeah.
Thank you, everyone.
Thank you, everybody.
Okay.
Bye.
Thank you.